Great, thank you, Paulina. Thanks, Paulina. Okay, good morning or good afternoon to some of you. I hope you were able to attend yesterday's excellent opening day of very informative sessions. My name is Stephanie Stobbe, and I will be chairing this morning's session on utopias as practices, refugee protection, and the coming futures. The description of our session states that the utopic vision of the international refugee protection regime focuses on international protection for those who genuinely need protection and ensures those who are responsible for criminality are held accountable. The 1951 Refugee Convention and its 1967 protocol, the 1948 Universal Declaration of Human Rights, and other international, regional, and national laws obligate states to provide protection. The 1998 Rome Statute of the International Criminal Court is a mechanism to address serious criminality. Application of such conventions and laws are applied to case studies of the European refugee crisis and its human rights impact on forced migrants in Greece, as well as resettlement of refugees in the United States and other places. The global compacts on refugee and migration, the call to action of the World Refugee Council, and other creative responses are examined. So before we begin, I'm just going to talk about some logistics. So please keep your microphone on mute or turned off so that we don't hear extraneous noises. And I will begin by introducing all the speakers, and then each of us will present our research and work. There will be time for a Q&A at the end, at which time you may unmute yourself and ask a question. So please think of questions that you would like the panelists to respond to. And unfortunately, Elise van Schletrecht from Netherlands is not able to join us today. So first, I'll begin by introducing myself a little bit more. I am professor and chair of conflict resolution studies at Menno Simons College, a college of Canadian Mennonite University at the University of Winnipeg. My areas of research include Southeast Asian processes of dispute resolution, peace building, and refugees and forced migration. I am an active educator, trainer, and ADR practitioner, and have worked in Canada, United States, South America, Europe, India, Asia, and Southeast Asia. I'm an editor of Lexington book series on conflict resolution and peace building in Asia. I serve on the executive of CARFMS, the expert advisory board for Asia Pacific refugee studies at Auckland University, and I am a fellow at McLaughlin College at York University. Next, we have James C. Simeon, a professor and head of McLaughlin College, Faculty of Liberal Arts and Professional Studies, York University in Toronto, who is past president of CARFMS. He serves as a coordinator of the International Association for Refugee and Migration Judges Inter-Conference Working Party process. His areas of research include international refugee law, human rights law, humanitarian law, criminal law, and public policy and administration. He has also served on the Immigration and Refugee Board of Canada and the executive director of the International Association of Refugee Law Judges. Third is Galia Ben-Arieh, who is a professor in the political science at Northwestern University. An international expert in refugee and forced migration studies, she has worked for over 20 years, bringing her expertise as an academic and lawyer to broaden our understanding of the rights and processes of refugee protection and the role of law in settlement and inclusion in host societies. She has conducted research in the Great Lakes region of East Africa, Germany, and the United States, and is the co-editor of Adjudicating Refugee and Asylum Status, the Role of Witness, Expertise, and Testimony, co-edited with Benjamin Lawrence, Cambridge University Press. At Northwestern, she founded and directed the Center for Forced Migration Studies and now directs the Research Collaborative on Refugees, Migrants, and Statelessness in the WCAS Center for International and Area Studies. And in 2018, she founded Compass, Community Partnership for Settlement Strategies. And fourth, we have Judith Gleason, who qualified as a solicitor before becoming an immigration judge in 1999 and an upper tribunal judge, a second appeals jurisdiction in 2002. She has a long association with the International Association for Refugees and Migration Judges and a career-long interest in comparative law. Judge Gleeson is a fellow of McLaughlin College, York University, and alumni of Lady Mary Hall, Oxford, and the Vrije Universiteit Brussels. We are honored to have Judge Gleason as the discussant for our session. So now I will begin with my presentation, and I'm going to share my screen. So my presentation is on the European refugee crisis and its human rights impact on migrants in Greece. In 2018, I decided to travel to Greece to conduct research on the refugee crisis, or the crisis of refugee policy in the region. So as you can see, the global trends in 2020 states that there are 82.4 million forcibly displaced people in the world. At the time of my research, there were protracted conflicts such as Afghanistan, Iraq, and Syria, and the Syrian civil war between 2011 and 2019 led to 13.2 million forcibly displaced people. And I think the 2020 stats states that there are 13.5 million forcibly displaced people with 6.7 million IDPs and 6.8 million refugees. And so in 2015, 1 million refugees and other forced migrants entered Europe. Thousands of boat people were dying at sea. In 2018, UNHCR estimated over 2,000 migrants went missing or died. And in 2016, an estimated 5,096 migrants died crossing the Mediterranean Sea. So refugees and forced migrants were often stuck in Greek detention centers and refugee camps. In 2015, the European Union struggled to adequately respond to the unprecedented 1 million plus refugees and other forced migrants entering its borders. Conflicts centered in the Middle East, from the multiple wars in Afghanistan and Iraq, the rise of ISIS, the Syrian civil war, and others have fostered ongoing political, social, and economic instability and human rights violations. The tragic death of 3-year-old Alan Kurdi and heartbreaking photo of his body washed up on the Turkish beach along the Mediterranean Sea in September 2015 highlighted the plight of millions of Syrian refugees. News media portrayed horrific mass drownings in the Aegean Sea. Thousands of forced migrants are stuck in various detention centers and refugee camps in Greece due to the EU-Turkey refugee agreement and other states' policies. As Greece tries to respond to the overwhelming number of refugees in a manner that upholds the human rights of these refugees, the detention camps were characterized by overcrowding, deplorable living conditions, mental health issues, and violence. And so my research questions were: 1, how is Greece addressing the mass inflow of refugees, asylum seekers, and other forced migrants? 2, what programs and services are available to help integrate refugees? 3, how is Greece meeting their obligations to EU and international laws regarding asylum? And 4, how can Greece, Europe, and the global community collaborate to address the refugee crisis? So the research methods I used were qualitative research methods of semi-structured interviews. These were conducted in English based on open-ended interview questions. The participants in the pilot project were professional participants who were involved in assisting refugees. The participants included Vice Mayor of Athens, UNHCR Greece Liaison Associate, Canadian Embassy counselors in Athens and Rome, national and international NGOs, including Catholic Relief Services, International Federation of Red Cross, Hellenic Red Cross, International Rescue Committee, Migration and Refugee Coordination Center and Observatory, and MOA Accommodations Program. 13 participants were interviewed in July 2018. So there are conventions and legislations. There are various rights that protect refugees and asylum seekers, including the 1948 Universal Declaration of Human Rights, the 1951 Convention relating to the status of refugees, and its amendments, the 1967 Protocol, and various European conventions, including the Charter of Fundamental Rights and the Common European Asylum System. The 1951 Refugee Convention is based on the Universal Declaration of Human Rights, Article 14, that asserts the right of persons to seek asylum from persecution in other countries. The Refugee Convention is a centerpiece of international refugee protection and the most comprehensive codification of the rights of refugees at the international level. Its fundamental principles include non-discrimination, non-penalization, and non-refoulement. And so my research findings, between 2014 and 2019, there were over 1.19 million sea arrivals and over 50,000 land arrivals in Greece. The Common European Asylum System provides guidelines for the Asylum Procedures Directive, Reception Conditions Directive, and Qualification Directive. So one, the Asylum Procedures Directive defines how people are processed. It aims to get set conditions for fair, quick, and quality asylum decisions. According to Athens Vice Mayor for Migrants, Refugee, and Municipal Decentralization, Lefteris Papagiannakis, receiving refugees and asylum seekers is a national policy, but the process has become much more complex. Quote, the whole system, the asylum system, was based on small numbers, the minimum. Now we have to increase the capacity very quickly in a very short amount of time. Many of the people felt that the state was not prepared to receive the influx of refugees in 2015, as it had no tools or mechanisms in place. 2, Reception Conditions Directive establishes provisions for asylum seekers while claims are examined, such as housing, food and clothing, access to healthcare, education, and employment. An accommodation scheme was developed and coordinated by UNHCR that worked with 12 NGOs in 11 municipalities in Greece to provide rented accommodations in apartments and buildings to vulnerable refugees and asylum seekers. At the beginning, Greece only had 12,000 placements in its accommodation scheme, but with UNHCR and European Commission support, another 22,000 placements were created. The NGOs identified that there is funding for rent and utilities and cash allowances for daily needs, plus a team of social scientists, accommodation supervisors, and interpreter for each case. According to Papagiannakis, there are approximately 3,500 unaccompanied minors and only 1,300 spaces, and specialized wards in accommodation centers only hold 20 to 30 children at a time. According to one interviewee, Greece does not have appropriate institutions to address mental health or facilities where people can stay to deal with their mental illness. 3rd, Qualification Directive administers international protection and non-refoulement under international human rights law. Access to employment, education, healthcare, and accommodation is a challenging task for Greece after having faced an economic crisis that began in 2009 after the global financial crisis of 2007 and 2008. In the economic crisis, Greece lost 25% of their GDP and continues to face significant challenges. In that context, dealing with the influx of refugees fleeing the Syrian civil war and other catastrophes is especially difficult. Papagiannakis states that some Greeks are asking, quote, why are you doing so many things for refugees and not for us? And that makes for a challenging political environment. One NGO described how Greece has had to implement austerity measures over the last 3 years, where there were cuts to social spending and non-existent resources. One interviewee responded that there are no integration programs in Greece, such as structured language education, vocational training, or job training to help refugees become self-sufficient. So the EU-Turkey statement was created to end the irregular migration of refugees and migrants from Turkey to the EU. Turkey agreed to prevent new sea or land routes of irregular migrants and asylum seekers from Turkey to the EU, to accept the return of all new irregular migrants and asylum seekers who arrive from Turkey to the Greek islands whose applications were denied. In return, the EU will settle 1 Syrian for every Syrian readmitted to Turkey, provide Turkey with 6 billion aid for projects to assist refugees and migrants, issue European visas for Turkey nationals, and resume talks to Turkey's membership in the EU. And in July or June 2021, the EU is considering 3.5 billion euros for Turkey to continue to host Syrian refugees until 2024 to stop migrants from entering the bloc. And so what are some of the research findings? One, since the EU-Turkey statement, there has been a decline in number of asylum applications in the EU, but this created a backlog in the Greek asylum system. People did not wait to apply for asylum in their preferred European country, but instead applied on the Greek islands. And two, thousands were stranded on Greek islands in miserable conditions. Many are calling it the containment policy. For example, in Samos Island, it has the capacity to house 648 people, and instead they hosted 4,000. In Lesbos Island or Moria Camp, it has a capacity for 3,000 and hosted 12,000 refugees. There are no provisions, no doctors, no psychosocial support. And three, Turkey is weary of receiving the largest number of refugees in the past 5 years. At the end of 2018, Turkey hosted 3.7 million refugees, with 98% of those refugees coming from Syria. In reality, the EU-Turkey statement is about containment rather than resettlement, by stopping refugees from leaving Turkey and by returning unwanted refugees back to Turkey. There are a few deportations back to Turkey, approximately 2,500 people in total so far, partially due to Greece's lack of caseworkers, interpreters, and appeals panels. But more importantly, as one NGO explained, the people who come to Greece are not likely to be part of the voluntary repatriation program. The principle of non-refoulement, which prohibits the return of refugees to a territory where his or her freedom is threatened, is a rule of customary international law. As such, it is binding on all states, whether or not they have acceded to the 1951 Convention or 1967 Protocol. And four, the EU-Turkey statement violates human rights and international laws protecting refugees and asylum seekers, according to various NGOs. So various NGOs discuss the effects of the EU-Turkey statement. Emmanuel Gu from Doctors Without Borders state that Greece has become a dumping ground for the men, women, and children that the European Union has failed to protect. The EU and Greek authorities continue to rob vulnerable people of their dignity and health, seemingly in an effort to deter others from coming. The policy is cruel, inhumane, and cynical, and it needs to end. Amnesty International recommends the EU and international community not return asylum seekers from Greece to Turkey on the grounds that Turkey is not a safe third country or a first country of asylum. And Kenneth Roth, Executive Director of Human Rights Watch, called this a crisis of politics, not capacity. And Papagiannakis, Vice Mayor for Migrants, Refugee and Municipal Decentralization, Athens, said, "For me, the most important thing is at the political level. We must demonstrate the political will to be involved." And so due to the sensitive nature and vulnerability of the refugee and asylum seekers population, I was not able to interview them in this research to obtain firsthand account of their experiences. I was given permission to visit Ilonia's refugee camp and observe the housing and living conditions there. Refugee camps on the islands were not accessible at that time. As you can see in these photos, it is located in the outskirts of Athens in an industrial area where there were no schools, grocery stores, or parks nearby. The roads were full of garbage and debris and sidewalks non-existent. It was pretty isolated. In visiting Ilonia's refugee camp, the NGOs working there provided me with the following information: that this camp opened in August 2015, and it has 295 containers or homes. These are shipping containers that have been turned into homes. And at the time, there were 1,500 people, including 520 children living there. Some refugees have been in the camp since 2016. They were allowed to work outside the camp and allowed to go grocery shopping. The children went to school on a school bus, as it was mandatory for children ages 6 to 15 to go to school in Greece. And there was a check-in and a check-out if you wanted to leave the camp and enter the camp. And so one of the NGOs stated that the containers are 5 stars compared to some on the islands. And so what are some recommendations for Greece? According to the participants, they thought that it was important for Greece to develop professional interpreters and language education programs. There are interpreters who have lived in Greece for a number of years who have been utilized to provide translation services. However, as one interviewer said, they are not professionally trained interpreters, and sometimes their personal lens and language get in the way of the actual translation. 2, provide employment for refugees and asylum seekers. Employment is key to integration in a third country. While I was in Greece, there were news stories of farmers who were looking for employees to work in the orchards, but were having difficulties in hiring refugees and migrants. Many farmers thought that this would be a good exchange. They need laborers and refugees need employment. According to Papagiannakis, the government currently does not have any partnership with such organizations to allow refugees and migrants to work in those industries, but that the government is working on solutions in light of an aging population and lack of available agricultural laborers in Greece. 3, provide adequate housing. As one NGO stated, people are looking to upgrade their accommodations over their migration journey, from boats to tents, to containers, to apartments, and beyond. More housing of refugees within the communities are needed that will prevent people from congregating in urban ghettos. The interviewees recognize that when refugees are accommodated within a neighborhood, they are contributing to the local markets through exchanging goods. And 4, provide trauma healing programs, including intensive psychiatric care. A number of NGOs are advocating for health facilities for those with severe mental illness where their needs can be met in a protected environment, and facilities specific to unaccompanied minor children with extreme issues to help address some of the challenges to integration. There are a few psychiatric care centers, but these are often full. So here's some more recommendations. All the interviewees confirmed the importance of coordination of settlement services and programs within Greece, as well as between the EU member states. They specifically mentioned the aging population in Europe and that this is an opportunity for Europe to embrace the refugees to create constructive coexistence. The state's government coordination of services and programs in Greece is important, including a platform of databases to share information and prevent duplication of services and programs. Other recommendations include resettlement in third countries. In response to safe passage, the EU should issue humanitarian visas to allow those who are in great need of protection to travel legally to a country to claim asylum that are in line with the Schengen border codes. The fact that resettlement in a third country is less than 1% of the refugees under UNHCR's mandate, it can be a tool to help provide protection to refugees quickly. 2, Global Refugee Sponsorship Initiative and private sponsorship. Canada's history, experience, and leadership in private sponsorship, which began with the Southeast Asian Indo-Chinese refugee movement in the late 1970s, is a model for countries that want to design new programs to help refugees. The Embassy of Canada in Italy has received a very small number of applications from refugees in Greece, Albania, Malta, Cyprus, and Sudan. According to the interviewees, the applications from Greece are usually driven by private sponsorship program where sponsors, families, and other connections in Canada identified people they want to sponsor, and a few refugees are referred by UNHCR from countries that cannot provide for them. 3, creative initiatives to assist refugees. The Global Compact for Migration, introduced in 2017, is an intergovernmental negotiation for safe, orderly, and regular migration that provides a framework for international cooperation on migrants and human mobility, including 23 objectives to better manage migration at the local, national, regional, and global levels. One of the objectives is to enhance availability of flexibility of pathways for regular migration. Arthur DeFer, a Canadian businessman and one of the founders of LCC International University in Lithuania, seeing the need of young people of college age in Iraq, Afghanistan, and Syria being displaced in different refugee camps or communities and resettling processes taking too long or even not possible, he proposed sponsoring and funding eligible youths to study in universities abroad. And so this program continues today in Lithuania. And so what is the current Mediterranean situation? As of October 24th, 2021, the total arrivals were 94,206 people, and sea arrivals were 89,054, including 6,736 to Greece. And the number of dead and missing to date in 2021 is 1,299, according to UNHCR. So Greece, as of October, the Minister of Migration and Asylum said, Greece is no longer experiencing a migration crisis, but humanitarian organizations and human rights groups say otherwise, according to an article by Fallon and Mali Shundas. The infamous Moria camp burned down to the ground in 2020. And since March 2021, according to various news sources, Greece has been pushing back asylum seekers and migrants from its land and sea borders, creating policies that make it difficult for people to enter the country to receive refugee status, making it easier to be rejected and deported, and harder to access accommodation, financial support, and other services. People are leaving Greece to reapply for asylum in other EU states, such as Germany. And Germany and the Netherlands courts have blocked people who are reapplying from being returned to Greece because of inhumane and degrading treatment. So there are still many issues to address in Greece and the EU. And the UNHCR states that legal pathways, such as humanitarian corridors, evacuations, resettlement, and family reunification must be expanded. And so this ends my presentation. Thank you. And now we will go to Dr. James Simeon, and he will be presenting his research on the utopic vision of refugee protection, assaults, exclusion, impunity.
Thank you very much, Stephanie. My approach is going to be a little different from Stephanie. Stephanie's looking at the state level. I'm looking at the international refugee protection regime. And I'm going to make an argument for how the process in terms of refugee status determination can be changed to eliminate exclusion. And this is sort of an interesting kind of argument, of course. And at the same time, try to advance the notion of ending impunity for serious international crimes. And the way I'm going to proceed is as follows. I'm going to, first of all, look at the ideal international refugee protection system and what it should be able to do. I'll review all of the principal refugee rights instruments, and you'll notice that they're structured a particular way. There's an inclusionary part and also an exclusionary part. I'll then move on to look at serious international crimes and the fight against impunity itself. I'll then take a look at refugee protection by states and the UNHCR. And as you probably know, both the states under the principally the 51 Convention and UNHCR under its statute determine refugee status. And I'll look at the rationale in terms of the exclusion clauses themselves, and principally they are to protect the security of the host country and maintain the integrity of the international refugee protection regime. So I'll look at the arguments presented principally by UNHCR in that regard. I'll also look at the arguments that have been made against the exclusion clauses, and particularly the use of the terms undeserving and unworthy that are used by UNHCR and others with respect to rationalizing, if you will, the exclusion clauses themselves. And I'll look at the arguments that others have made that why those are really not appropriate any longer. And then I'm going to look at alternatives, possible alternatives to the exclusion clauses for refugee protection. And then this is a lot, I know, within the limited time that I have. So Stephanie, if I go over, please let me know. And then I'm going to make the argument that you have to prosecute individuals for their serious international crimes whenever the evidence warrants this, of course. and it's reasonable to assume that you would actually get a conviction. And then I'll end with some concluding thoughts and reflections. So in a utopian world, of course, there wouldn't be any refugees. So I wouldn't be making these kinds of arguments, but obviously we don't live in that utopian world where there are no refugees. But if we've got a utopic vision in terms of the international refugee protection regime, then what would you expect the international refugee protection regime actually to be able to achieve? And I've got on the slide here something that we're all familiar with. And that, of course, is Article 1A2, which is the definition of who is a refugee in the 51 Convention. You have to have a well-founded fear of persecution, of course, for reasons of race, religion, nationality, membership in a particular social group or political opinion. You have to be outside your country of nationality or former habitual residence. Or owing to that fear, you're unwilling to avail yourself of the protection of that particular state. And then it also, of course, covers stateless persons, those not having a nationality, but being outside their country of former habitual residence as a result of such events, unable to, or owing to such fear, unable to return to it. But I'm going to argue that in this ideal international refugee protection system, it should achieve at least two things. One, that all those who are genuinely in need of refugee protection will be granted international protection. And secondly, all those who are responsible for criminality, especially those individuals who are responsible for serious international crimes, will be held criminally liable. So if we look at the refugee rights instruments, you'll find that the principal ones, there are a lot more than these, but I've got the principal ones on here. The 51 Convention, the 69 OAU African Union Convention, the 1984 Cartagena Declaration, the 2011 European Union Qualifications Directive. You'll see that the structure is pretty straightforward in terms of both having an inclusionary portion, which is Article 1A2, and an exclusionary portion. And I'll get to the Article 1F, which I want to focus on. But you see that mirrored in these other instruments as well. They have both inclusionary portions as well as exclusionary portions. So that is really the classic way, if you will, of international human rights and refugee instruments having these particular characteristics. But I'm going to make the argument that the exclusionary portion really can be dispensed with. And you may or may not agree with this, but I'm going to try to present that argument. And I'm not the first one who's presenting such an argument. But let's look at the fight against impunity. And this is, I'm going to go to the Rome Statute of the International Criminal Court. And I want to draw your attention to Part 2, jurisdiction, admissibility, and the applicable law. And under Article 5, crimes within the jurisdiction of the court, it outlines what the jurisdiction of the court is. And as you know, or as many people do know, Article 5 really identifies the most serious international crimes. So that's the crime of genocide, crimes against humanity, war crimes, and the crime of aggression, which is the most recent one that's been added to this. And if you look at the specific provisions within the Rome Statute, it defines in great detail what constitutes these various crimes. So if you look at Articles 6, 7, 8, and 8 bis, you'll see that genocide is clearly marked out in terms of what its features are, crimes against humanity, war crimes, and so on. And for those of you who are familiar with the exclusionary system and how it operates now under the various legislation within the different states that apply this, this is actually included within Article 1FA, and I'll get to that in a moment. But if we look at why the International Criminal Court has been established, I think this is important to take a look at. Obviously, it's to investigate and when warranted to try individuals for these gravest crimes, these most serious international crimes, and that's genocide again, war crimes, crimes against humanity, and the crime of aggression. But it also covers a number of other interesting points if you look at their website. It also points out that the court is participating in a global fight to end impunity. And through international criminal justice, the court aims to hold those responsible and accountable for their crimes and to help prevent those crimes from happening again. And the court cannot reach these goals alone. And one of the important things to note is the ICC will only deal with those crimes once all other avenues have been exhausted. There are other ways, of course, to refer cases to the court. The Security Council of the United Nations can do that as well. But the ICC is not the only court that's responsible for this. National courts, of course, are critically important in terms of this. And in fact, if you look at the record of the ICC, most of the individuals who have been prosecuted for war crimes, crimes against humanity, this has taken place actually at the national level. So under the complementary process, the ICC only gets a certain number of those cases that go forward to it. And of course, if you're not a state signatory, like China, for example, or the Russia or the United States, then you're not going to of the ICC. Now, there are some special cases in terms of that. We can talk about that later, but primarily the broader mission of the ICC, and I think this is really important, is that justice is a key prerequisite for lasting peace. So international justice can contribute to long-term peace and stability and equitable development in post-conflict societies. So it sees its role much more broadly than simply international justice, I would argue. It is really fundamentally trying to end, if you will, extreme violence, organized violence, and contribute, if you will, to maintaining peace and international security. So ending impunity and advancing international justice, I think, is one of the main goals, obviously, of the ICC. But I think there's a broader goal in terms of the United Nations and the international community as well to advance international justice. So if you look at the definition of Amnesty International for international justice, it says international justice means accountability for the most serious crimes that take place, genocide, again, crimes against humanity, war crimes. Likewise with Human Rights Watch, it defines international justice in terms of accountability. And it says through fair trials for genocide, war crimes, crimes against humanity. And they see this as essential in terms of building respect for human rights. So if we look at the 51 Convention and we look at the exclusion clauses primarily here, they fall within Article 1F. And again, if the system that this utopic vision, this system should be one where those people who are responsible for these serious international crimes ought to be prosecuted. And right now, what we have under Article 1F, it states specifically that those individuals who fall within the convention in terms of who is a refugee can be excluded where there are serious reasons for considering that he or she, for example, has committed a crime against peace, a war crime, or a crime against humanity, as defined by the international instruments. And again, I want to note here that the ICC's jurisdiction falls specifically with respect to Article 1FA. A crime against peace is actually the crime of aggression, and war crimes fall within that, crimes against humanity. And some would say the crime against humanity would also incorporate genocide as well. So right now, decision makers, judges, justices are looking to the Rome Statute in terms of the definition, because it says here as defined by the or in the international instruments, so they would turn to the Rome Statute in terms of defining, in fact, what those particular crimes would constitute. Article 1FB refers to those who have committed serious non-political crimes outside the country of refuge prior to the admission to that country as a refugee. And Article 1FC refers to those people who are guilty of acts contrary to the purposes and principles of the United Nations. So I'm going to get to my main argument in a moment, but I want to look at the rationales that have been provided by principally the UNHCR with respect to the exclusion clauses. And I'm going to turn to or draw your attention to the note on exclusion that UNHCR's executive committees, its standing committee has looked at. And here again, they use the term, the idea that the individual is not deserving of protection as a refugee if they've committed these serious international crimes, and therefore they should be excluded. So they argue that the primary purpose in terms of the exclusion clauses are to deprive the perpetrators of heinous crimes and serious common crimes of the protection of refugee protection, and to safeguard the receiving countries from these criminals who could constitute a danger to the security of that particular country. They also make the argument that the exclusion clauses help to preserve the integrity of the asylum system. You don't want to be giving refugee status to hardcore criminals or people that commit these heinous, serious international crimes. I think that's fairly straightforward, and no one's really going to disagree with that, I would argue. The maintenance of the integrity of the institution of asylum is critically important as well. And they also point out, as you can see there, the exclusion clauses form part of the definition of who has the right to enjoy asylum. And also, if you look at further rationales and the most recent guidelines that have been issued by the UNHCR with respect to the exclusion clauses, Article 1F, they also argue that the rationale here is that certain acts are so grave as to render the perpetrators undeserving of international refugee protection, and that such persons have to be excluded because they are really, would be, to give them refugee status would be to abuse the institution of asylum. And also, you don't want them to avoid, obviously, legal accountability for the acts that they've perpetrated. They also make the argument that the states concerned can choose to grant the excluded individual stay on other grounds. But the obligations in some situations might be that international law requires that those individuals be prosecuted or extradited to be prosecuted elsewhere, such as the ICC. So keeping all of that in mind, then what are the arguments against the exclusion clauses? So I want to refer to a number of people who've criticized the UNHCR and the way it's really either presented the exclusion clauses themselves, and others who have made the argument that the exclusion clauses really now are outdated. So Ben Saul has made the argument that human rights are rights, not privileges, and cannot be suspended for bad behavior. And I think it's really important to keep in mind that asylum itself is one of the most fundamental human rights that we have. And Stephanie made reference to the Universal Declaration of Human Rights of 1948, Article 14, which says all of us are entitled to be able to access asylum. So it's a fundamental human right. So you don't lose these rights if you commit serious crimes. And I think that's the point that Ben Saul is making. You shouldn't be arguing that these people are undeserving of one of the most fundamental human rights that all of us should be entitled to. Satvinder Justice has also been very critical of the use of terms such as unworthy and undeserving. And he would argue that that's really not appropriate under the human rights system that we have today. And as you know, human rights are universal, they're interdependent, they cover everything. And so we're entitled to this by our humanity and to protect our human dignity. So we can't be deprived of these particular rights. So the argument has been made in 1951, we did not have this fully blown human rights system that we have today. In the last 70 years, there's been a plethora of human rights instruments that have been developed and have come into force. The international criminal law was certainly not as well developed in 1951 as it is today. There was no ICC back then, of course, and there weren't all of the ad hoc UN international criminal courts that have been put into place. So the international criminal law system is fully developed, and it wasn't obviously back in 51. So people like Justin Mohammed have made the argument that the exclusion clauses really have outlived their usefulness in international refugee law. And in fact, he makes the argument that the exclusion clauses can perpetrate injustices rather than upholding the integrity of the refugee protection system. And I find...
Sorry, you have a minute to wrap up. Thank you.
Okay, so let me just come to my conclusions. And I can, perhaps in the questioning, I can advance those arguments a bit more. So without excluding a person from refugee protection and simply determining the person cannot be granted refugee protection, the definition of convention refugee would not include persons who are liable for serious criminality or actions that are contrary to the purposes and principles of the United Nations. So what I'm arguing is that you can actually eliminate all those people who are criminally responsible by incorporating a provision within Article 1A2, which would exclude all of those people who are responsible for serious criminality. That would eliminate then these arguments that people are making about using the terms undeserving and unworthy of refugee protection. It's a part of the definition in the inclusionary portion rather than creating an exclusionary portion. These individuals where the evidence is clearly evident that they should be prosecuted, have to be prosecuted. And the problem right now is that states are using immigration procedures to make these individuals inadmissible rather than actually saying that you are responsible for the crimes and either by universal jurisdiction or extraditing them to be prosecuted elsewhere. These people are not being held accountable for the serious international crimes. So in the end, states have to bear the responsibility for prosecuting these individuals. And of course, if these individuals would be persecuted if they are deported back to their countries or would not receive a fair trial, then under non-refoulement, of course, they would still be protected and stay with the state. Sorry, I had to rush through my presentation. So I thank you very much for your attention.
Thank you, James, for your presentation. Next, we have Galia Ben-Arieh, who will be presenting on designing U.S. refugee protection policies for long-term well-being.
Thank you, Stephanie. And James, I'm very much looking forward to talking about your paper in the discussion, in particular because I teach comparative constitutionalism this quarter, and we were just doing the death penalty yesterday, and I think a lot of your arguments are paralleling now in my mind, some of that stuff we talked about. So I think now, though, we're going to turn our attention back much more in line with what Stephanie presented, which I feel like we have a commonality on this panel, and that we're both thinking about how countries respond through their integration policies to the short and then long-term well-being of refugees, and in particular, how they've reneged on some of the promises of refugee protection. Whoops. Okay, yeah, there it is. Okay, so in my work as a scholar, I spend a lot of time thinking about the questions of what does a strong admissions policy depend? And just to take us through some of the common arguments about this, some people tend to look at the humanitarian considerations that that a refugee admissions policy depends. They overtly usually state that they're humanitarian. Scholars have pointed out, though, that a lot of, and actually even by law, refugee admissions is very closely tied to the foreign policies of different countries. It's also very much tied to the domestic politics. In fact, in her presentation, Stephanie, and I added this to my slide, talked about the crisis of politics. And so we could even think about the current what we call the refugee crisis as not really being a refugee crisis, it's a crisis of domestic politics, or it might be a crisis of foreign policy interests in the world today, or it might be a dispassion, kind of an overwhelming feeling, or people talk about it too. There's so many crises that there's a drain on how people could feel about humanitarian crises in the world today. From my perspective, I want to try to shift how we think about on what does U.S. refugee admissions policy depend, because the three that I just mentioned, of course, are all from the country's perspective. And I think that there's too little thinking about admissions policy being dependent on refugees themselves. How do they view the policies? What do they think about the policies? And could we somehow shift, if we're thinking about utopias here, which we are at this conference, what would policies look like if they were more client-centered, and they're consumer-centered, and thinking about what should they depend on to make them a positive experience for refugees who often have no choice in where they're going. So if we take a step back, I liked that James brought up what's the utopian promise of humanitarian protection. So I also added in this slide, because I also started with, in my research and my thinking about this, with what was actually the utopian vision of our humanitarian protection. And I was pretty surprised by the quotation that I have here, because it's true that the promise is about receiving individuals who qualify for protection. That's about how we define refugees. So that's a definitional problem of, are you or aren't you a refugee? And as James pointed out, are you included or excluded, and what should be that basis? In the 1951 Refugee Convention, that takes up one article. It's just at the very beginning, there's a definition. But most of the convention is not really about defining who is a refugee. It's about what happens if we do define them as such. And that was because back in 1950, and the United Nations felt that they wanted a stable world, and people out of place lead to worldwide instability. So the idea of the promise of humanitarian protection was never actually so focused on refugees as such. It's focused on a stable world. And so the most stable world, they reasoned, was one where people were self-sufficient and independent. So the reason why we try to get people out of this place of independence and not belonging is so that they could lead an independent life, and they would no longer have to be maintained by any international organization, and that they would be integrated into an economic system in their countries of asylum. So taking that as our point, at least in the United States, we've really fallen short on this promise of an independent life. Refugees don't pick the country where they are supposed to come to. Their admissions, where they are placed, for example, in Evanston, Illinois, where Northwestern's located, is just the luck of the draw. They didn't even hear of that place. And there's the visual images of some really terrific films of refugees that talk about the resettlement process. And God Grew Tired of Us is what I'm thinking of. And there you see them just seeing their name on a list in a refugee camp, and then they just read some word, Illinois, and they could, they don't know. Illinois is a flyover state. Nobody knew. Nobody intentionally tried to get resettled to Illinois. So they didn't know that. It was a luck of the draw. They have to pay back their cost of travel when they come here. They don't pick where they're going to live. That's decided before they ever get to the United States by a refugee agency that's struggling to find affordable housing. And so signs on with some landlord and commits a refugee family to $1,500 in rent a month. So at this point in my story, they're not leading any independent life because they come with an average debt of paying flights for about $3,000, housing costs. They don't have a job yet. So the refugee agency places them in a minimum wage job doing janitorial services, working in hotel laundries or at the airport. And then they quickly sign them up for benefits. So we don't actually practice the policy in any way that's going to lead people to be independent. It's a stroke of luck if they do wind up to be independent. But yeah, since 1975, when the United States has been resettling refugees, we've resettled 3,200,000, and now it's a little bit more. I did this number. Unfortunately, it's not all that much more because Trump really decimated our resettlement program, but we're starting to resettle people again. And there's been about 3,000, for example, in the last month in refugees resettled to the United States in September. But more or less, there's about 3,500, let's say, refugees resettled since 1975. And that means there was about, as of today, about 150 at the very most who were resettled in Illinois. When you think about that, since 1975, that's actually not that many people. But yet, we're at CARFMS very concerned about refugees, and they're a key population that we're focused on. So it's a lot for us. So in my work, I was concerned with the long-term outcomes of those refugees. So the main refugees that I study then are people in Illinois. So those are Burmese, Iraqis, Syrians, Congolese, and Bhutanese, because those are the main people we've resettled. And I've been focused mostly in Illinois as I build a model. And my concern, and this is what I also founded COMPAS, so I could work directly with refugees, is that most of these individuals who are adults just earn $10.64 as their average full-time hourly wages. And most of them have marketable skills, but they're just untapped. There's no effort made to actually create a system where they could be economically independent of public benefits. So this got me thinking, and I started to look back, because I'm a lawyer, at the Refugee Act. And again, what was the promises? What is there a gap? One of the questions I had this is all well-intentioned. So was there a utopia in our 1980 Refugee Act? How did that look? So our 1980 Refugee Act, in fact, did set up a very strong legislative start for what our Office of Refugee Resettlement would be seeking to do. That very much did seem in line with trying to create a way in which people could be economically independent. So in section 412A, it has 4 key provisions. And the main point of this is that they're separate for right now. I want you to keep hold of that there's an A, a B, a C, and a D in the law. And the first one is that there should be resources for employment training and placement to help them become self-sufficient. A separate one is that they should be learning English so that they could become effectively resettled as quickly as possible. They are supposed to be given cash assistance, so not to discourage economic self-sufficiency, and women are supposed to get the same opportunities as men. So the point here is just that if you really look at this carefully, very much, as we probably all know, it's geared towards people achieving self-sufficiency, which is different than economic independence as a concept, which is the first problem. Okay, so what we see, though, that happened since the creation in 1980, so we see even in the actual law that we see a shift from this promise in the 1951 convention of an ideal of economic independence that even guarantees people could bring their assets along. One of the right is you could travel with your assets or go gather your assets that you left behind in your country, to a concept, a much baser concept of self-sufficiency. But then what happened even further is when the law was implemented through regulations, which come under executive power, there was a second shift. And what happened was is language acquisition became completely subservient to getting a job. So the shift turned self-sufficiency and language acquisition as separate goals into a concept of workfare. And so you're only learning base English in order to get that minimum wage job. I did work doing a consultation in Utah, and I spent a lot of time in a refugee program run by the Mormon Church, and they were teaching the refugees words of color. They are working in their Goodwill Center that they have, sorting clothes. But so most of their English language, when I studied it, was geared towards teaching them basic words that just prepared them to work in a hotel laundry. It wasn't preparing them for any other kind of particular employment that would lead to economic independence. I draw a lot in my work then on Eric Tang. He wrote the book Unsettled, Cambodian Refugees in the New York City Hyper Ghetto. And he was one of the first people who really put words to this condition, this problem. And he talks about two very powerful concepts. One is liberal warfare, and liberal warfare that is practiced by the United States in waging wars like we did in Vietnam, Cambodia, and then of course in Afghanistan under the guise of freeing people. But of course it's a terrible concept because we don't free people, we create refugees. And he connects that to the liberal warfare being waged upon refugees after they arrive, because they're placed in what he calls hyper ghettos. So they're put in poor neighborhoods because that's the only place they could be housed. And then because of this concept of self-sufficiency, they're thought of as a model for traditional poor people and welfare recipients. So in other words, what he's saying is that liberalism is dependent on blaming the victims. So we blame the victims for not having achieved or gotten out of a ghetto, but at the same time, we make the condition of getting out of that ghetto impossible. So what happened as a result of all this in the United States is already in 2010, we did start having a crisis of politics. We had a congressional report by Senator Lugar, which studied refugee resettlement in different main cities and issued a very condemning report on our resettlement program called Abandoned Upon Arrival. It had a lot of interviews, a lot of good anecdotal data about what was going on in localities. So, but not too long after that, I know 5 years might seem like a long time, but in policy worlds, it's not so long. We had a Paris bombing, but in between 2010 and 2015, I was engaged internationally with colleagues like James Simeon in a lot of different meetings where we really thought refugee resettlement could be a really good hope for the world's refugees. And if we just grew refugee resettlement programs, then maybe we could really contribute to ending the long duration of refugees in camps. And it turns out, though, that growing anything like refugee resettlement requires data. And there wasn't a lot of data. There was no data really on refugee resettlement, at least not long-term outcomes. And it's hard to sell a policy to a country if you can't show results. So I became really interested in the data problem, and I founded a refugee research program at Northwestern to take that on. I founded it in 2015, right before the Paris bombing, and then everything changed in the United States. So we're here now in 2021 with some new beginnings, and so I'm back to doing it. So I'm focused, and this project has been getting started again, focusing on the data issue in our refugee resettlement policy. And in looking at it, I connect the idea that we've had declining support for our refugee program because we don't really have any sense of how it matches or maps onto refugee lives. So before Trump, we were really concerned with questions about the long-term value In the Trump era, there was no effort made to really develop any research on refugee resettlement, because we just had a reactive research agenda to try to keep any semblance of the refugee program alive, as he just dismantled it. But what is clear about the problem with the field of refugee resettlement is that all the data, there's two main buckets of problems. One is that there's very few or none really studies of the economic benefits and integration of refugees. And the reason why is because there's a main data that the government collects called the ACR, that's the Annual Survey on Refugees, but they're only concerned because the policy itself is a 5-year policy. So all the data that's collected by refugee resettlement agencies only goes to 5 years. So we only have a short-term portrait, and it's only trying to track whether they became self-sufficient, and self-sufficient is defined as having a minimum wage job. So the metrics are so small, but then of course, in the realities is that schools, teachers see students struggling, communities are having to pick up the cost of refugees. So there's kind of a big gap between the data that seems to be showing these glowing outcomes of self-sufficiency and the reality that communities are faced with refugees in their communities, which is showing that they're really struggling. And collecting this data is too hard. Some people have tried, like the Migration Policy Institute, to go beyond 5 years, and they try to do it quantitatively by relying on census data, but there's no way to know in the census who are refugees. So it's not really a good approximation, and it's still then not speaking to the real issues communities are facing. There's also a strong conflation between immigrants and humanitarian basis. So if you're lumping everyone together, you're really tracking immigrants, but immigrants are not refugees. And so this I think I've already talked about. In the interest of time, I'll speed this up. This is just a bunch of scholars who connect the need to have a better public attitudes of refugees with more better scholarship on how do we, that the public perception of refugees is very much connected to how refugees are perceived to have employment, housing, access to healthcare, language training, all these things. Mental health is very important if you want to change public perception of refugees. Okay, so the last part of this is that the focus then of what I've been doing and what I was doing last summer and will be doing going forward is really focused on a provision in the 1980 Refugee Act, which says that the number of refugees we resettle in the United States has to be connected by law to a description of the estimated cost of their movement and resettlement. And the law mandates that we have an analysis of the anticipated social, economic, and demographic impact of their admission to the United States. This became a huge political controversy when Trump took office. Because the outgoing director of the Office of Refugee Resettlement physically took the data with him because he knew it would be destroyed. He then took a job and worked at Open Society, and through channels, along with more left-leaning pro-refugee groups, published a study of that anticipated social economic impact, which was of course very positive. And then the Trump administration dismissed that as fake news. So this data war has been ongoing, and it's not settled because there isn't any data. Okay, so here it is in the actual law, and we see that part of the problem in the data is it's not even clear what I put on the side here. There's different branches of government that are in charge of things. So part of it is kind of an institutional problem that our office, the DOS is Department of State, Office of Population, Refugees and Migration. They're in charge of doing some of the analyses. And then the Office of Refugee Resettlement is in charge of studying the anticipated social, economic, and demographic impact. But they've kept all that data secretive for far too long.
I wonder if you can wrap up.
I'm wrapping up. Yeah,
Okay,
I just have
thank you.
this data void. And so then what I've been doing then is forming partnerships. And this past summer, this is the last slide, I did a data deployment. So the data deployment is trying to find a great strategy to improve data and analytic data of local governments and refugee providers. And the goal is to make this analytic data easily accessible also to refugees so that they could also have a better agency over their lives and know where they want to live, because the data is kept from them too. And so what we learned mostly, and this is the conclusion, is that there isn't data. And when we did the data deployment, it's incredibly hard. There's just not data about refugees anywhere. Thank you.
Great. Thank you so much for sharing your research. Yes, we have a lot of commonality in terms of these topics. I'm going to turn it over now to Judge Gleason to say a little bit about what she has heard, and then we'll open it up for a Q&A after that. Thank you.
Well, that's been fascinating, hasn't it? It's always a privilege to come to CARFMS. I mean, James and I worked out I've been coming every chance I got since about 2014. And I always learn an enormous amount, and I'm privileged to be in such eminent company today. There is a utopian quality to the whole decision to migrate to another country, whether you do so as a refugee or whether you do so as a migrant. I mean, 300,000 years ago, 250, 155, nobody seems quite sure. We can all trace ourselves back to the Horn of Africa and mitochondrial Eve, can't we? And there is hope in the refugee migration, a hope which isn't always fulfilled, as you were saying, Galia. But I think it's just extraordinary coming out of the dystopian situation that was the Second World War, and the Refugee Convention and the Human Rights Convention and the Nuremberg trials, of which we celebrate the 75th anniversary this year, that we are now in a situation where there are 193 countries recognized by the UN, although there may be more. Some people outside the UN claimed that 215, 247. 146 of those countries have signed up to the Refugee Convention. 147 have signed up to the New York Protocol. Overall, there are 148 countries of the 193 that the UN recognizes, where you can rock up and say, I'm in trouble, you have to help me. The response is not always perfect, but if that's not utopian, I don't know what is. And the other utopian quality, I think, is these international conversations that we have. We think together about where we've been and where we should be going. You go right back to Resolution 8.1 of the General Assembly, the first General Assembly of the UN, where it recommended to the Economic and Social Council that it take into consideration the principle that the problem of refugees is international in scope and nature. And we do, don't we? We may not always do it perfectly, but we do that. And bolted deep into that original resolution, predating the Refugee Convention, predating the European Convention on Human Rights, which, James, I'm sorry, comes the year before. So there were human rights by 1951 enshrined. And there had been an international military tribunal. The Nuremberg trials finished in 1946, didn't they? But still, I take your basic point. Bolted into that is that the protection does not extend to war criminals, quislings, and traitors, but only to genuine refugees. There's something about the population buy-in that requires there to be some level of exclusion. We can all argue about what is the correct level of exclusion, but I'm not with you that you can have no exclusion at all. because I think what you would do is you would start losing countries from that group of 146 who are prepared to open their doors and take people in. Stephanie, it was very interesting to hear you talking about Greece and the common European asylum system. What absolutely baffles me is why, faced with the migration in 2015, for which no country was really properly equipped, they didn't use the 2001 Temporary Protection Directive, which is full of very sensible rules for how you handle a mass migration, including time-bound permissions, protections, regular review. It's really rather like the rules that used to apply in the US for Haitians that Trump overturned. So there is this wonderful instrument, and the EU didn't use it. I don't know why. I'm absolutely baffled by that. It's not a perfect system. Some of the regional instruments are better. We're looking down the barrel of yet another big migration out of Afghanistan, where we've got a really dystopian situation. We're looking down the barrel, not very far down the line, of a big climate migration, which the Refugee Convention doesn't answer at the moment, although some of the regional instruments do. But just the level of global cooperation that goes on is really extraordinary. If we're talking about utopias and the coming future, there is a utopian quality to the fact that we are all prepared to pitch in, not perfectly, and do stuff to help people who can't safely go home. And that, I think, gives me hope. But I'd like to read you something from Robert Schuman, the Schuman Declaration of, I think it was, the 9th of May, 1950. Now, Schuman, despite his name, was a French foreign minister. And this is the opening moves to what became the European Union. He said, world peace cannot be safeguarded without the making of creative efforts proportionate to the dangers which threaten it. The contribution which an organized and living Europe can bring to civilization is indispensable to the maintenance of peaceful relations. In taking upon herself for more than 20 years the role of champion of a united Europe, France, well, he was a Frenchman, has always had as her essential aim the service of peace. A united Europe was not achieved, and so we had war. Europe will not be made all at once or according to a single plan. It will be built through concrete achievements which first create a de facto solidarity. And then he goes on to recommend what became the European Coal and Steel Community, and then the EEC, and finally the EU. But both of the instruments that I've talked to you about, the Resolution 8.1 and the Schuman Declaration, recognize that this is a global problem, that we can't get peace unless we all roll up our sleeves and muck in. We've had an awful lot of pressure on that global cooperation. We've been through some tough times, and we've probably got more tough times to come. But we have to remember that when people migrate to our countries, and I know, forgive me, Stephanie, I know you know this personally, they do it for a great future. They do it with a utopian ideal. And for all its flaws, in the 75 odd years we've had it, the Refugee Convention hasn't done such a bad job. So those are my thoughts on what were 3 fascinating presentations. Absolute privilege to be on this panel. Thank you.
Great, thank you so much, Judge Gleason, for your comments. And I really like what you emphasized, that refugees and these issues is a global problem, and that we all need to work together and cooperate with one another in order to have peace, and that we need to all take responsibility in how we address this. So thank you so much. And yes, thank you to James and Gaia for your presentations. And so I'm going to open it up now for a Q&A. So if some of you have questions, you can either type it in the chat or you can raise your hand or turn on your camera and unmute yourself. It depends on which platform you're on. But if you have a question, then please unmute yourself. Judith, I see you are unmuted. Do you have a question? No. Okay, so while we are waiting, oh yes, go
I'll
ahead.
have a question. So
Okay.
I'll ask my question to James, if that's okay. So when you were talking about the exclusion clause, it reminded me, so yesterday, like I said, some of the discussion about the death penalty, because my students were looking at the US opinions of Scalia and Breyer versus South Africa. We were looking at Justice Albie Sachs and the decision where they banned the death penalty. And in South Africa, similar to what you were talking about in terms of the including the people who've committed violent crimes, and also Scalia, slightly different. So I'll start with Scalia. He says that institutions that you should either decide you should deal directly with the issue, just like you said, with the person. Either you should treat their crime directly and not intermingle a failure of institutions, which seems to be what you're saying, that we should deal with the person. If the person committed a crime, then churn them through your system. But don't rely on a separate system, the immigration system, to deal with the crime, because those are two different problems. So that seems to fit. And in South Africa, very differently, they said that, obviously that if you commit someone to death, that extinguishes all rights. And in a sense, that's what you're saying, that just because somebody committed a crime, it doesn't cast them outside of the whole system of a community of rights. And so that seems to me the same logic of why they said you can't put someone to death, because death is a finality and that extinguishes all rights. And in my mind, would you say that that's true? That would be the question.
Yes, I would agree with that. Yeah, I'm much persuaded by Ben Saul's argument that you don't lose your human rights if you do bad things for bad behavior. And that's why I think I would say, and perhaps this is a bit provocative, but I'd say that most civilized societies don't have a death penalty. And I know in the United States, some of the states still do. I never thought I would agree with Justice in the Supreme Court in terms of his position.
I didn't either.
So Scalia is right. I think in essence, the argument is that when you're deciding whether or not the person is a refugee, the definition should be clear. I mean, it says for reasons of, it says that you have to be outside your boundary. Why doesn't it also say you can't be a criminal? You can't be responsible for serious crimes. Yeah, but it says it in Article 1FA. It doesn't say it in Article 1A2. So I think that's the point that I would make, that you deal with it directly. And if there's sufficient evidence to establish that the person can be brought to trial and prosecuted and likely get a conviction, then you should do that, because it promotes international justice. And it advances the whole notion of eliminating the culture of impunity that exists in the world today. There are many people that are responsible for serious international crimes, and I'm not talking about direct perpetrators, but others that actually support this and make it possible through complicity. And they should be held accountable for that. That's sort of my view. And that's why I would be inclined to support that you deal with all of that right at the beginning. You don't say that people are undeserving of the most fundamental human right possible, which is the access to asylum. I wouldn't say that. In other words, UNHCR takes a position, you have to do inclusion before exclusion.
Yes.
So it seems to me that if you're going to do inclusion before exclusion, then part of the definition of who is a refugee should be in the inclusionary portion. It shouldn't be the second step. So that, I think, is what I'm persuaded by.
But is it in fact the case that Article 1F stops you being a refugee? Is it not the case that Article 1F just says, okay, you meet the Article 1A definition, but you don't get to be protected because it doesn't say you're not a refugee? So I think
Well, I'll leave
with
that
you,
for
Frank.
Nancy, who's the expert on this. Nancy, do you want to weigh in on that?
Nancy, are you here?
Nancy Wiseman?
Yeah, I thought that was who you meant. How are you, Nancy? Where are you?
She's not responding.
She's hiding.
Yeah, and I think
Come out.
yeah, that's a really, really interesting question. And I know James had come to my class, my refugee and forced migration class, and one of my students said, well, what about restorative justice? And rather than just thinking of it in terms of this punitive and exclusion, what about for some cases? Obviously, there are some cases that should go through the criminal justice system, but there may be some other cases in amongst the refugees, asylum seekers, where we might look at restorative justice as a mechanism to try and address, you know, these kinds of issues and allowing them to repair the harm that has been done, and depending on the situation, you know, that person was in. And so the idea of balancing mercy and justice, you know, I think need to come into play. That yes, it's important to have justice, but can we also think about mercy as well, and how do we balance that and meet the needs of both sides? Yeah,
I mean, that argues that you have someone to whom to restore the justice. If you can prosecute in the country of refuge, then almost by definition, you must have some of the people who've been harmed there to be witnesses. Of course, the classic problem is that all the witnesses are in the country from which they have fled. And whereas it appears from the international paradigm that you should prosecute in the host country, in practice, if you've got no witnesses, if you've got no evidence, it's hugely difficult. And many countries, therefore, practically never prosecute.
Yeah, the complexities of doing that gets in the way. Are there any questions from the audience for any of the panelists? Jessica Norman, do you have a question? I see your
Hi. Thank you. I'm with the Immigration and Refugee Board of Canada, and I'm in the central region. I'm an adjudicator at the Refugee Protection Division, and previously was a refugee lawyer in sole practice. So I just wanted to mention, first of all, it's been a fascinating discussion. Thank you, everybody. And on this definitional question of who is a refugee, one interesting thing is that despite what the UNHCR says, the Canadian jurisprudence has clearly developed along the lines of exclusion as a threshold issue. So we don't turn to whether or not you, in our parlance, we call it Section 96, which is the Convention refugees, or Section 97, the people in need of protection otherwise. We don't turn to that if we find that someone has been excluded, whether it's on Article 1E or 1F. Not to say that that's inherently the right approach, but I do think it's interesting. We avoid the whole problem in that way, but it's still there, and I appreciate the discussion today. It's been really fascinating.
Could I respond and then I'll invite Jessica and Galia to respond. I know we're running out of time.
You have a minute before they turn us off on
that approach is barring the person from access to asylum, I would say. And in the United States, if you're involved in a war crime or anything else, you're not considered for refugee status at all. And I think that's what you're suggesting, Jessica, is equivalent to that.
Yeah, I'm not sure exactly how the United States processes the how they determine exclusion. In Canada, you actually make your full refugee claim in most cases and present all your evidence, but
Well, I think that that might have ended our session. I know it automatically does it. Thank you, everyone, for being here and participating and listening to our presentations. Thank you so much, and thank you to James, Galia, and Judith for your participation in this panel. Thank you.
Thank you.
Thank you,
Stephanie,
everyone.
for putting